Good morning and welcome to Rising Friday. Emily, I had said that I wouldn't be here this week, but I just like to keep you and the viewers on their toes.
Surprise!
Here I am. Wait, what do we have today?
So Emily Kopp is back with more of her fantastic reporting on a key virologist with ties to EcoHealth Alliance that tried to kill the lab leak theory.
And Jordan Sheridan discusses why Governor Rick Snyder is walking away scot-free in the Flint water crisis scandal.
And we'll hear from a reporter on the national strike in Ecuador. But first, the Supreme Court ruled this week that the Biden administration can end the Trump-era Remain in Mexico policy, which required either jailing asylum applicants from Central America or denying them entry to the U.S. until their cases are resolved. The Hill's Rafael Bernal joins us now to discuss the future of the Remain in Mexico policy. The Hill's Rafael Bernal joins us now to discuss the future of the Remain in Mexico policy. Rafael, thanks so much for joining us.
Good morning. Thanks for having me.
All right, let's start off just with some clarification between Remain in Mexico and Title 42. People are confused, I think, about what each one does differently. So could you just sort of clarify what the difference is? They're totally different things, but what is the difference between Title 42 and Remain in Mexico?
It is confusing. They're pretty much sister programs. The Trump administration first put in Remain in Mexico to prevent allowing asylum seekers or potential asylum seekers into the country while they awaited their turn in immigration court. Later, when the pandemic came along, to prevent even more asylum seekers from coming in or from requesting asylum and staying in the United States, the Trump administration put in Title 42, and that basically said, if you're caught at the border, you're a foreign national, you didn't have permission to be here ahead of time, there's a pandemic going on, we're going to expel you either to Mexico or to your home country, but we're not even going to process you. We're not even going to ask you if you're an asylum seeker. But fundamentally, both those programs were geared at having fewer people come into the country through what the Trump administration termed was the asylum loophole, a term that obviously is not widely accepted.
Right, and so where does this leave us now? So Remain in Mexico is ruled unconstitutional by 5-4, and so Title 42, is that just dependent on CDC guidance, or where are we now?
Like well, Title 42, Title 42 is still, the end of Title 42 is still blocked by the court. So the Biden administration is forced to continue implementing Title 42 the way until yesterday it was forced to continue implementing Remain in Mexico. A key difference, however, is Remain in Mexico depends on an agreement with Mexico. So it jumps into foreign policy. So the court said, courts can't be telling the executive how to conduct foreign policy. That was number one. And number two, the court's reading of immigration law was that the administration has actually a wide range of options. They don't have to jail everybody who's pending an asylum case. They don't have to expel anybody who wants asylum. But they can do these things. So broadly, I would say this ruling is a win for executive powers over foreign policy and over immigration policy.
That is a really good way to put it. And it ended up before the Supreme Court because states sued when the Biden administration sought to get rid of Remain in Mexico. And now Justice Kavanaugh wrote actually that it hadn't been used that often, that there weren't that many cases that came to be over the course of the Trump administration. Can you talk to us about the accuracy of that? How did this actually sort of play out over the course of the Trump administration? Asylum, people might not realize, is a very narrow legal category. And so it's all very complicated. But what did this actually look like in practice?
At some point, there were 70,000 people subjected to the program. So these are people necessarily from the so-called Northern Triangle, Guatemala, Honduras, El Salvador, who came through Mexico, asked the United States for asylum, said they had a fear of returning to their countries, and then basically got plopped back over into Mexican border cities. Now, there are parts of Mexico that are perfectly safe, but the border cities are not it. So these people with fewer resources, they're poor, they wouldn't be coming unless they were poor, disadvantaged, and afraid. They were put in these cities that are dangerous. They started creating these migrant camps, basically had no other option but to create sort of refugee camps in North America. That is something you had never seen historically. And it was very dangerous. There was a lot of crime against them, against these migrants. There were murders. There was definitely a lot of sexual assault in these camps, and there wasn't good policing on the part of Mexican authorities, who were sort of forced into this option by the Trump administration's threats, sort of economic threats for them to cooperate on migration. So it was a bad humanitarian situation. Yes, it was only 70,000 out of, say, 1 million people, I'm throwing that number out. So a relatively small proportion of people, but there was a humanitarian crisis detonated by Remain in Mexico.
And so help me out. Why is Title 42 allowed to stay in place? Not just allowed to stay in place, but why is the Biden administration required to continue to carry out a Trump-era policy, if they're not required to carry out the other similar Trump-era policy, and if the executive has this discretion that we're talking about? Why? Connect those dots for me.
Basically because Title 42 hasn't made it to the Supreme Court. There's a little bit of Remain in Mexico that's also in the Title 42 case, the administrative part. Did the Biden administration wind down that policy correctly? And that's really, did they cross the T's and dot the I's and file the proper paperwork? And that hasn't been decided in Remain in Mexico. That's going back to the lower courts, but that's really not going to affect the policy. That also hasn't been decided in Title 42. And in Title 42, there's a broader decision to be made about whether the Biden administration correctly removed the sort of the pandemic era, the CDC order that allowed DHS to implement this immigration policy. Let's remember, Title 42 on its face was a public health policy, not an immigration policy. So it's really, the difference comes down to legalese.
I guess last thing on this, and then we're going to move to the EPA versus West Virginia case. What is the practical implication of this? Because often you see like a big news item like this, and then you see events down the road, and you say, well, wow, this is all because of what the Supreme Court just did with X. And you're like, I'm not so sure that actually is connected. So how much real impact on the United States are we going to see as a result of this ruling?
Most likely none, but there is the possibility that this ruling gets turned into disinformation, and the smugglers have been very good at spinning, whether it's a Trump administration policy making the border harder to cross, and then they say, oh, now you really need my services if you want to go to the United States, so they grow their business. Whether it's a Biden administration policy taking away a Trump administration policy, and then they say, look, now it's really easy for me to get you in the United States, and then they grow their business. The fact is, the smugglers will spin any news on immigration to their benefit and to grow their business. So basically, any movement on immigration to one direction or the other, they know how to benefit out of it.
Right.
So that is going to be a consistent issue until the smugglers are attacked somehow themselves.
Absolutely. No question about it. Thank you so much for joining us, Rafael.
Glad to be here.
Really appreciate it. Well, as Ryan said, we're not just talking about this particular case. We are going to turn to another ruling from yesterday, but before we do that, I want to add the point exactly to what Rafael just said, is that if you talk to migrants, the reason they are huddled in those border towns is because they really are so desperate. They don't necessarily qualify for the very narrow legal category of asylum, but they are so desperate because they're caught in this judicial tug of war, this judicial back and forth. They know that if something changes, they want to be, they literally will say this, we want to be the first people in. They will huddle next to the bridge itself. Like we talked to a bunch of Haitians huddling next to the bridge itself. And we have at the Federalist, we have a documentary coming out on this. And I think we have some footage of that. But if you talk to them, we have all of them saying this, like they want to physically be close to it because because as the minute the Supreme Court decides one thing, or the minute a lower court decides another, they know that sometimes there's openings.
Right, and I'm sure, to Rafael's very good point about the disinformation networks, I bet WhatsApp just lit up all throughout Central America yesterday with kind of twisted news that the Supreme Court had basically opened up the borders. Because if you're a coyote, you're a smuggler, like that's what you want to tell people. Like now is the time to go. And you might even add, look, Trump wants to run for president again. So your opportunity to get in now, and as a result, you're going to pay me double.
Yeah.
Because now is the time to come. So I think he's right, and you're right. But if it goes the other way, if the Supreme Court had ruled the other direction, they'd come up with some other spin.
Yes, it's
saying like you got to hurry now before they implement this and before this and that and other thing. So come right now, and then you just get massive refugee camps along the border.
Yes, and it's marketing for their business. And it's interesting that Rafael used the term refugee camps because it's exactly what it is. When we stepped into one of them, my colleague was like, okay, so this is a refugee camp. It's exactly what it looks like. You can see that in the footage. But that is, the cartels absolutely exploit this judicial back and forth and this confusion, and the information travels down. And also, when people do get in, the information that they did get in, it might just be one person who was able to hire a lawyer or who did cross the river successfully, et cetera, but that travels to many, many more people. That one person did get in, so it's worth a shot. That's the sort of cost benefit they make.
And there's some interesting contrasts between this one and the EPA case. This case was 5-4 with Alito kind of in the lead on the dissent. And he argues that even though, as Robert says in the majority opinion, that the word may is crucial to this, that the DHS may do X, Y, and Z. That means the DHS has discretion. It's not required by statute to do any particular different thing within its mandate. Alito says no, it really should. And if Alito had one more vote, he would have said no. Department of Homeland Security has no discretion. It's told by Congress that it's going to do, and it's told by the former Trump administration, it's going to put this Remain in Mexico place, so therefore it has to move these people into Mexico. In the EPA case, the Environmental Protection Act, the Clean Water Act, all these others are quite clear about what the statute is saying. The statute is saying air pollutants are an existential threat to the people living in the United States.
Right.
And therefore, the EPA is empowered to devise regulatory systems in order to bring those air pollutants down within acceptable levels. EPA, and then there's the Air Quality Act, Clean Water Act, a bunch of other ratifying and expanding acts over the time. And each time that Congress appropriates money for the EPA, they're essentially ratifying their earlier mission. So for 50 years, Congress has been saying this is the goal of the EPA. This is what we want the EPA to do. But you have the majority this time saying, well, no, actually, we don't want them to do that. So on the one hand, DHS is required by this reasoning to carry out a mission. On the other hand, EPA is not allowed to carry out the very specific mission that Congress gave it unless Congress passes a brand new law that says, no, all the things that we said before that we wanted to do, we really meant that. Like, you really have to do that, which seems to me that they've given up even trying to be consistent about the stuff, that it's all results oriented and then working backwards from there.
Well, I think that's generally a problem with our Supreme Court these days anyway. But I would say that this is a really interesting excerpt from Justice Kagan's dissent in the EPA case. She said, members of Congress often don't know enough and know they don't know enough to regulate sensibly on an issue. And then she continues, members of Congress often can't know enough, and again, know they can't, to keep regulatory schemes working across time. And I think what she's getting at there is sort of the heart of the political divide in many, many ways over the scope of government, the scope of the administrative state, the federal government, Because if you have something like the EPA, I think the conservative justices were saying this is such a dramatic policy that you need to have congressional authority in order to carry it out legally. But what Justice Kagan is saying is this massive regulatory agency exists to regulate. That's why it exists. And the conservative justices are getting at this idea that I think we've talked about this before, it actually kind of cuts at the foundation of the administrative state. I forget what case we were talking about last year, but it was
about the SEC and I think the Fifth Circuit.
Right.
Where they basically said the SEC isn't constitutional.
It's illegitimate. Yeah, it's constitutionally illegitimate.
3 judges in the Fifth Circuit, right?
Yeah, different than the Supreme Court, of course. But I actually think this case really got at that too. Is that like if it is not an enumerated power for the EPA, then Congress must enumerate the power in order for the EPA to exercise it.
Right, and the way that the EPA is designed, it says, okay, at the time of the creation, we know about these air pollutants. These are a problem. But the EPA is also empowered to identify through these processes new air pollutants. And there are checks and balances on that. They had to go Massachusetts first EPA, or whatever it was. There was a Supreme Court case that said, okay, yes, carbon dioxide does count as an air pollutant. The courts affirmed that. I think a lot of people on the right might be like, well, you know what, screw the EPA, fine. So let's try to take a different one. Say the Federal Reserve. Now you've got the Ron Paul crowd who's going to be like, yeah, that's right. The Fed is unconstitutional.
That's right.
Ron Paul crowd aside, the Federal Reserve established in 1914 and given a mandate, and then in the 1970s is given this dual mandate. Its dual mandate is to do full employment and to keep price stability. And this new Supreme Court idea would suggest that every time there's kind of a new economic circumstance, let's say a pandemic.
Or immigration circumstance.
Or a shipping crisis, where you're getting bottlenecks and so the types of inflation and the types of employment issues or automation are different than in 1914 when the Federal Reserve was created. You'd have people saying, well, the Federal Reserve's interest rate hike here, or their quantitative easing, or their repo buybacks, or whatever program that they're doing to meet their mission of full employment and price stability is unconstitutional because these members of Congress in 1914 didn't foresee that we'd have a pandemic, not just in 1919, but again in 2020, or they didn't foresee that we'd have a shipping crisis at the same, that coincided with the pandemic, or a supply chain crisis, or the concentration of purchasing power on the internet. So they'd say, well, now Congress has to write brand new Federal Reserve Acts, like brand new laws every time that the Federal Reserve has to confront new economic circumstances that it hasn't precisely dealt with in the past. And that is just a recipe for an ungovernable society, which I think is actually the goal of the kind of Lochner era element here, that they don't want the government to be able to govern.
Well, here's a relevant excerpt from Alito's dissent in the Remain in Mexico case. He says, due to the huge numbers of aliens who attempt to enter illegally from Mexico, DHS does not have the capacity to detain all inadmissible aliens encountered at the border, and no one suggests that DHS must do the impossible, but rather than avail itself of Congress's clear statutory alternative to return inadmissible aliens to Mexico while they await proceedings in this country, DHS has concluded that it may forego the option altogether and instead simply release into this country untold numbers. So you could say he then continues, this practice violates the clear terms of the law, but the court looks the other way. And I think it's mentioning Ron Paul and the Federal Reserve is extremely interesting in this context, because I think probably there's a good argument that in a narrow originalist interpretation of the Constitution, that is completely correct. The Ron Paul take on the Fed is completely correct. And in a very narrow originalist interpretation of the Constitution, it is very difficult to see how a massive organization like the EPA, which in a country that is high-tech and globalized and interconnected in a way now that it wasn't then, in a way that like air pollution is something that like we have to have international cooperation with in order to make a dent in it. It's not as though states can really regulate that in a way that doesn't affect the whole country. So yes, I mean, it's just very difficult to build that on a proper constitutional foundation. And I think you very much, that's what's revealed in these arguments.
Although not that hard. So it's definitely true that you can find people who were around at the time of the founding, Madison, let's say, Monroe, who would say, yeah, no, none of this is legit. But you could also find people like Hamilton,
Yes.
who was another co-author of the Constitution and the Federalist Papers, who would, if he were alive today, he'd be like, of course the Federal Reserve is good, EPA is good, all things are good. There's this great letter between, I think it's Madison and Monroe, complaining about how Hamilton is starting to build canals.
Yes.
He's starting to fund canals under what maybe was a general welfare clause, and Madison's like, the federal government funding canal projects? This is an outrageous expansion. So who's the originalist? Is it Hamilton or is it Madison?
Yes.
And Hamilton's like, are you insane? How are we going to have a country if we don't build canals? How are you going to get to Erie? Walk there?
Imagine explaining gain of function research to Madison.
Madison would be like, hey, whatever anybody wants to do, they just do.
Right.
Can't have laws.
Right.
Yeah.
Well, yeah, but it's absolutely true, and I think the originalist interpretation, as it's been adopted on the right, is obviously Madisonian.
Right. They want to go to particular people at the time.
Yeah, I think that's true, and the argument would be that those
Imagine Hamilton coming back and being like, wait, originalist as in me? I was there, and you all are completely wrong about this.
Although, I mean, Hamilton wasn't exactly, it is very hard, and this is what people like Kagan and Sotomayor get at. It is very hard to apply some of the writings to what we look at now. If you are talking about things like air pollutants that are post-industrial and are not only across state lines, but across international borders in ways that really matter, really matter. And so, yeah, I mean, I think that conversation is inappropriately, lacks the nuance that it probably needs. But it is very difficult to sort of go back and think about how you could even apply a lot of that.
Right, and I think they're not even really trying. They don't like the EPA, and they're like, what grounds can we use to undo this?
It's an interesting question because it goes to what we do about the Supreme Court period. Like, a lot of people on the left say, well, there's nothing about 9 justices, let's pack the court, let's do this, this, and this. And I still think that the wisdom of the founding documents is the balances of the system. And that, I think, it's not a limited government necessarily or a big government thing. It's a balanced government.
But it's getting thrown wildly out of balance.
I think there's an argument for that.
Yeah.
And I think actually part of the argument, I would say the use of a lot of these policies at the border is a good example of that. I would say we still have the AUMF that was authorized after 9/11. I mean, it's being abused in different directions because we're so wildly off course.
Yeah, headed right for the ditch.
Yes. Well, on that just happy, characteristically Rising Fridays, Ryan Grim note, we will tell you what's on our radars next.